Hello, friends. My name is Ismail Shahtakhtinski. I'm the principal immigration attorney at IS Law Firm. Today is July 27, 2023. It's 12:34 p.m. Washington, D.C. time, and we are having our weekly live stream on immigration news and information. I will briefly tell you about expediting your immigration case, whether it's asylum case with Asylum Office, or your immigration case in immigration court, or any other case with the USCIS, United States Citizenship and Immigration Services. And then I will answer questions from our audience. If you have any questions, any immigration questions, it doesn't necessarily have to relate to today's topic. You can post it in the chat section of this video, and I will answer all of the questions during the session. This live stream. We have live streams every Thursday at 12:30 p.m. Eastern Standard Time, which is New York and Washington, D.C. time, and where I briefly tell you about the immigration news and then answer all of the questions of our audience. If you know anyone who is interested and who wants to ask questions, you can tell them that immigration attorney Ismail Shahtakhtinski from IS Law Firm is answering all of the questions live every Thursday at 12:30 p.m. Please share the link. Please also like and subscribe to our channel. In our channel, we post video blogs about different immigration procedures, answering questions from audience, and we conduct this live stream. So if you want to be notified of the next live streams and the topic of the next week's live stream, please subscribe to our channel. Again, it's every Thursday at 12:30 p.m. And if you have any questions, please post it in the chat section. I will do my best to answer everybody's questions. So I hope everybody's having wonderful summer. And I wanted to tell you what you can possibly do, your lawyer, to expedite your immigration case. So I separate the immigration cases into three different categories. Well, four different categories. One is the immigration case that is going through USCIS, United States Citizenship and Immigration Services. That includes all the family reunification cases, the family petitions, your citizenship application, change of status, work permit, travel authorization, and so on. So that's category one. Category two of immigration cases are those cases that are filed with the State Department. So you file it with the USCIS first, but then it goes to the State Department. It goes through consular processing, through U.S. consul. Those are for individuals who are being sponsored who are outside of the United States. They're not in the United States. The third category are asylum cases. Those cases are filed affirmatively with Asylum Office, USCIS, United States Citizenship and Immigration Services, but this time it's with a separate division, which is called Asylum Division. Those are affirmative asylum applications. Those are individuals who are already in the U.S. with some kind of visa. They have not been placed in removal proceedings in immigration courts, and they want to affirmatively apply for protection for asylum in the United States. The fourth one is in immigration courts. So if you have a asylum case, for example, or if you arrived to the United States through CBP-1 or through U.S. border, southern border, or you have been apprehended and placed in removal proceedings, or if your case was referred after the affirmative application was referred to immigration court. So that's fourth category. So what can you do to expedite your cases? You have a hearing coming up, it's scheduled way into the future, sometime in 2 years, 3 years from now, and you want to have it heard faster, or you have filed for asylum, have been waiting for years, or you filed an application with the USCIS or State Department and have been waiting for years, what you can do to expedite those cases. So there are two types of expedite procedures. One is formal expedite procedure, and the second one I'm going to talk about is something that you or your lawyer can do, extracurricular. I usually say something that is not in the manual, that is not a standard procedure, but there are tricks that you can do, legal tricks that you can try to maneuver your case to have it heard faster than it would be. So the formal expedite request according to USCIS, can be placed on several bases. So if you filed your application with the USCIS, you have a I-130 or adjustment of status, work permit, and so on. You can file an expedite request by calling USCIS after you have the receipt number and notifying them of the reason for expedite request. Now, when I say call USCIS, everybody's probably alarmed because the USCIS is, very well known, notoriously not answering calls or putting you on hold for hours before somebody picks up, or there's automated service that you cannot get around. So, but with expedite requests, if you call USCIS and you hear the automated response, if you tell them you want to place the expedite request, your call will be answered within about 5 to 10 minutes, sometimes immediately. So with expedite requests, they do pick up the call, and the USCIS agent will be on the other line, and they will ask you, what is the basis for your expedite request. You will need to provide them your receipt number, your date of birth, name, and then you have to provide the explanation, the reason for the expedite request. It can be either urgent humanitarian reasons, such as severe medical condition, or danger, or threat, or horrible living conditions for family members, or health condition, as I said, for you or your health condition, or it could be somebody who's close to you, and the expediting your case will somehow help either to bring that family member to the US or for you to travel to be able to see that family member. It could be your parents or close relatives. So that's one of the ways. The second way is if there is a severe financial loss expected to you or to a business to entity that you work for. So based on that, you can place an expedite request. You will have to provide information. You will provide it over the phone, and then the USCIS will send you an email within approximately 2 to 3 weeks where they will ask for that confirmation. Now, severe financial loss is one of the formal expedite request categories, but it doesn't mean just because you were not going to be able to work and earn your living, you have to demonstrate more than that, basically a financial loss more than that. For example, we've been able to place an expedite request for a family where only one family member was working. There was a spouse and children, and we demonstrated the financial abilities of the family, their savings, which was basically none, and the individual wouldn't be able to work during that time. The family would basically go completely broke. So that's how we were able to expedite once a work permit. Then we were able to expedite an advance parole, demonstrating that the applicant was working for a business in the United States, and she had to travel abroad for a business meeting, and the success of a deal, which was a substantial deal between the two companies, depended on her ability to be able to travel there and to meet with the board of directors and so on. So I'm just bringing these examples as those expedite requests, what can be used. Now, in terms of medical reasons for expediting your immigration process, it has to be somebody close. Like, let's say, if your parents, if they're elderly, they're sick, and you've been waiting here for a long time and you want to go and see them, you want to travel to maybe a third country if you're an asylum applicant and so on. So that can be used. Then there is interest of the United States. There is national interest. For example, during the pandemic, all of the individuals who worked in healthcare, you didn't have to be a doctor. We got expedite requests approved immediately for IT personnel who are working, or a security person who's working at the hospital, or IT worker who was working as a contractor for the medical facility. So those were approved automatically. So there are, those different ways. There is information online on how to place the formal expedite request with the USCIS, and you can follow those. Now, what if you have asylum case pending in Asylum Office? The asylum offices, they don't follow the same formal request. There is no phone number you can call and give your receipt number to request your asylum case to be heard faster, or your interview to be scheduled faster. But what you can do is you can email the asylum office. So each asylum office has email address, And in the asylum office, there is no specific criteria. It's case by case. And an actual officer is going to review your expedite request and decide whether it warrants to put your case ahead of others. So you have to provide all of the documentation, proof, evidence, and explanation. We usually recommend to gather, let's say if it's a medical reason, to gather medical records, to make a written statement from you and maybe family members who also can attest to the reasons why your case have to be put before others. And so then everything gets emailed to the asylum office at the same time with all these explanations. Now, they do approve expedite requests, I would say more liberally, the asylum officers do than the USCIS. And asylum officers, once they approve it, they place your case in the expedited list. Now, that expedited list, as you can imagine, is expanding. And in the past, when we had asylum interview expedited, we could get an interview scheduled within a week or two after the expediting of the case. Then now we have case that has been expedited about 8 months ago, and it's still pending. And when we write to the asylum office saying, what happened, guys? You approved the expedite request. Why are you not scheduling the interview? They've been telling us, look, we have this extensive list of cases which all have bases. We expedited those, but now we have this expedited list, which is, creating a backlog of its own. So you should take that into account. Don't be alarmed if they expedite and they're not scheduling you faster. There is no expedite request for the expedited cases. So don't try to do that. And that will probably take time from asylum office, and it can irritate them. So unfortunately, even the expedite process itself is backlogged with asylum offices, but it still helps. It takes your case out of the general backlog where you may be waiting for another 5 years or 6 years, 7 years. We have some asylum cases which have been pending with asylum office for about 7 years or plus, with no interview scheduled yet. The longest I had a client who waited for asylum interview for 10 years. That was a client from Sudan. Traditionally, many cases from Ethiopia and Sudan, those cases, for some reason, they have been significantly backlogged. They're being put on the back of the line. But eventually, they scheduled an interview, but that was 10 years. That was the highest mark. Now, any given time, our law office, we have approximately, I'd say, close to 100 cases or so that are pending. They're still catching up. They're trying to schedule interviews for some of those pending cases that were filed since 2015 or 16, but it's very slow. So if you have bases, you can email asylum office. Your lawyer can email the asylum office and provide all of the evidence in support, your written statement, and try to expedite your case. Now, some asylum offices also have a short list where you can contact them. It doesn't hurt to send them an email, even if you don't have basis for asylum, for expedite request, just to email them and tell them, I want to put my case in the short list. Now, if you do that, or if you're placing an expedite request in your asylum case, you must make sure that your asylum file is complete, meaning you already filed all of your supporting documents, country condition reports, all of the evidence, witness statements, and most importantly, your written statement, which is full and complete with all of the information that you need to provide to the asylum office. So you need to make sure you do that before you request to expedite, because once you place it on the short list or expedite your case, it can be very quick, meaning once they give you notice, they can give you a very short notice. That's the point of the expedite or short list. And plus, if you don't have your complete file, if you don't provide all of the documentation to the asylum office, they're not motivated to expedite your case, because they know that if they give you a call or if they send you a notice of the interview a week from now, you will probably load them with a bunch of documents and your written statement and so on that you haven't provided in the first place. So if you have a pending asylum case, make sure you complete everything, you provide all of the information, all of the documentation and support before you place an expedite request, or if you ask them to place you on short list, your case on short list. I've had cases where we asked to place an expedite request or place the case on a short list, and I had the asylum officer call me, a couple days later and tell me that, hey, I have an interview opening because somebody canceled, 2-3 days from now. Do you want to take it? And then we would either take it, or if the client is unavailable or I'm unavailable, then we would ask for another date. But typically we would make sure to accommodate it, because that's a very rare chance to have an asylum office to call you or your lawyer and tell you we have a case 2 days from now, yes or no, you want to take it or not. If you don't take it, you might fall back again to that long backlog and wait for years again until your asylum interview is scheduled. The third type of the case is the State Department National Visa Center. They also have expedite request procedures. They have an email where you can, I believe it's called NVC Expedite, but if you type on Google NVC, which is National Visa Center, expedite request, you will get that information, how they want you to request to expedite your case. And they have this email address where you would basically provide all of the evidence and so on. The NVC and the consulate, they operate with that email address. So you don't email separately to the consulate. Now, with that being said, the consulate can expedite your case on its own, circumventing the State Department National Visa Center. And we have done that. We recently did it for a Uyghur national who lived in Turkey, who was stuck in Turkey because he couldn't come to the United States until his immigrant visa was approved. And the NVC process would have taken a long time. So we wrote to the U.S. consulate in Ankara, and Ankara replied back to us saying, please send us all the documents that you would normally submit to the NVC, to the State Department, and we will take all the fees and everything. So we will take care of it directly with circumventing the NVC State Department. So we did that and successfully got his immigrant visa. We also did that recently, just like yesterday, actually, for a case that had interview yesterday that was in Congo, where we also went through the consular process directly with consulate rather than going through the NVC, National Visa Center. Well, in that case, we tried to go through NVC, but it didn't work. So that's why the consulate took all the documents directly. Now, the fourth category of the cases, as I said, is immigration court cases. If your case is in immigration court, if you are in immigration court in removal proceedings, you probably have asylum case pending or cancellation of removal or relief under Convention Against Torture. So if you have those cases, and if you have a judge who scheduled your individual hearing or master hearing years out in the future, then you can ask to expedite your case. In that case, your lawyer would file a motion to advance. That's what the motion is called. So if you want to talk to your lawyer, if you have a lawyer, you want to talk to them and say, can we file a motion to advance? And motion to advance can be filed on many bases, even on the basis that your affirmative case took too long, or your family members. Maybe you're here alone in the United States because you crossed the U.S. border with Mexico through CBP-1 process, but your family members are stuck abroad, and your master hearing or individual hearing is scheduled in 2026, and now it's 2023. You understand that you're going to have to wait for at least 3 more years before you can even file a petition to bring your family members as asylees. So you can file a motion to advance with the immigration judge, and the immigration judge is going to decide on it. Now, they also liberally approve it. Depends on the judge. Some judges just keep it on pending, don't rule on the motion until they have a sudden opening. We had cases where we filed motion to advance and had the immigration court schedule individual hearing 2 weeks from the date we filed it. Sometimes they have windows. Sometimes cases get canceled or somebody asks for continuance and so on. And then those cases move to another date. Now the judge has opening in the calendar, an extremely busy calendar, and they want to fill that opening. So if they see the motion to advance from you, which says that all of the documents, everything is provided, you don't have to supplement, your case is complete, you're ready to appear anytime they schedule it, then the judge and the judge's clerk are motivated to put your case in that window so you can be heard much faster. Sometimes you save many years of waiting time by doing this motion to advance. Now, if you your lawyer can also contact the judge's clerk and communicate with the clerk. And sometimes we have already some communication relationship with the clerks. Or when I go to a hearing, another hearing with the same judge, then I can put a word to the clerk and say, if you have a window, I have a client who's ready to go. We'll take it. Even if it's tomorrow, we'll take this hearing. You can also do that at the master hearing. Your lawyer at the first initial hearing, you can tell the judge that, Judge, we're ready to go. If you have anything available, some cancellations, we'll take it. So instead of waiting for the individual hearing to be placed in line in the judge's calendar, 2 years out or 3 years out, you want to do it as soon as possible so you or your lawyer can tell that to the judge at the master hearing. But again, be careful when you do that, when you request to expedite or advance your hearing or schedule expedited individual hearing, you must be prepared. You don't want to have the judge schedule it and then down the road you or your lawyer are going to say, oh, we need more time to prepare. That will severely irritate the judge. And judge can actually deny and say, look, you told me to book your case earlier, to expedite your case, and now you're telling me, unless you have a very strong reason something unexpectedly happened, the judge may actually deny the motion and say, no, you show up at this hearing, we're going to hear your case on this date because you made me to take this date for you, to block this date for you. So be careful. You want to make sure that your case is complete, whether it's with immigration court or with immigration office, with the USCIS, asylum division. You want to make sure your file is complete, your documents are filed. I cannot stress this enough because I see too many immigration court cases and too many asylum cases in asylum offices where the applicants got wrong advice, whether it's from their lawyer or from some individuals who are trying to help them, who actually a lot of times hurt those applicants by trying to help, that told them just file your application, you will supplement it later. Don't do it, file your complete application forms and documents. Now, aside these formal procedures, as I said, you and your lawyer can also, your lawyer, probably they're not going to talk to you, but your lawyer can talk to the clerk or the judge, or sometimes I'm a member of Immigration Lawyers Association, so we as immigration attorneys would communicate with each other. I had a case where, it was about a year and a half ago that I had to put that case, expedited as soon as possible. And I contacted my colleagues through U.S. Immigration Lawyers Association, and we found that somebody else wanted to actually move their case further down to another date, what we call it, to continue the hearing on the case. And we agreed to basically swap. So the judge didn't care, as long as this client wanted to be heard earlier, the other one wanted to be heard later, then we swapped the position. So there are creative ways to do that. Sometimes with asylum offices, if you supplement the documents, or if you, move from one location asylum office to the other, and at that point supplement and place the expedite request, you may have a chance to be heard, to have your asylum interview scheduled faster. Because once you move from one jurisdiction to the other, your asylum file gets sent to the new jurisdiction, and the new asylum office is going to look at it, and they may decide, if they see that the file is complete and everything is there, and you're asking to expedite your case, they may be motivated to just schedule it for any first available window, rather than finding the place in line to put your file, to register all that, to put you in the backlog. So that's why it might be interesting to to request the expedite process through that way. So, as I said, this is pretty much brief summary of different ways to expedite your case. There are creative ways to do it. I cannot, go on and on. I don't want to block all of this entire time. I want to be able to answer questions. I see lots of questions from audience members in the chat section. I want to be able to answer everyone's questions. But regarding your expedite requests and your pending case that you want to expedite, if you do want to talk to me, you can contact me. There is a consultation. There is a linked how to schedule a consultation. That's consultation link. You will also in that link see all of the answers to frequently asked questions about scheduling a consultation with us. It's on the chat section. You can see there. So you can use that to schedule a consultation with me. Again, my name is Ismail Shahtakhtinski. I'm the principal immigration attorney at IS Law Firm, and I've been practicing immigration law for 16 plus years in the United States, and I'm a member of American Immigration Lawyers Association, and my primary focus is on handling asylum cases, immigration court cases, but our law firm handles all kinds of cases, whether it's naturalization, family reunification, E2 investor visas, business immigration, all of those things. So waivers, J1 waivers, change of status, and even visitor visa applications. So contact us. And if you have any questions, please post it in the chat section. So I will go on into answering all of the questions that are posted. And if you have any questions, post it in the chat section. So, and again, I asked everyone, if you like this video, if you like the format, if you like how I'm providing this free advice during these live streams, please press like and please subscribe to our channel. And if you don't like it, again, please let us know. Post a comment in the chat section. I will be glad to review and address it. All right, so Anu is asking, hi, I got a question. How soon can you file for reentry permit if you are I-360 green card was consular only after landing in USA, or after one gets a green card abroad, can stay in India for 4 extra months and apply? All right, that's very confusing. Apply for reentry permit, not go to USA at all to save money if all your benefits are already denied. What benefit? I mean, from what I understand, Anu, you're asking, you're saying that you got your green card, you got your petition approved, you're coming to the United States, you got your petition approved, your visa approved through consulate, you're coming to the United States as a permanent resident, and you're saying, can I not come and just apply for reentry permit? The answer is no. For reentry permit, you have to be physically in the United States. You have to enter the United States. Plus, you don't become a permanent resident unless you enter the United States. So you have to leave India, you have to travel to the US, enter the US, so that you become permanent resident. Otherwise, you will not become a permanent resident and you will lose the whole thing. If you don't travel here within 6 months after you got your visa, you will have to start all over again. All right, so you have to do it. Now, once you're in the US, you can file for reentry permit. You can file it the minute you enter the US. Now, you have to prepare. There are forms and documents and supporting evidence. All of that has to be gathered, prepared beforehand if you want to save time, so you can file it right away. You also have to be in the US for biometrics, for fingerprinting appointment. Now, typically, they would schedule fingerprinting appointment within about 1 month or so from the date you file your application. Now, if you were fingerprinted recently, then USCIS doesn't schedule fingerprinting appointments. Since the pandemic, they started reusing the fingerprints from previous cases. So anytime you file something with the USCIS, you're expecting biometrics appointment, you will likely get a notice saying you don't have to do biometrics, we reused your previous biometrics. So that can happen. But to apply for reentry permit, you have to be in the US. Now, for anybody who doesn't know what reentry permit is, reentry permit allows US permanent residents, green card holders, to be absent from US, to travel abroad and stay there for the period of up to 2 years. And nobody's going to say, nobody's going to take away your green card based on that absence, based on the length of that absence. Traditionally, if you stay too much outside of the US, more than 6 months, or more than 1 year, definitely you will be questioned a lot, and you will probably lose your permanent residency. Or if it's more than 6 months, you will be questioned. You can overcome it, but that's difficult. So to avoid all these secondary inspections and issues why you were absent for so long, you can apply as a green card holder. You can apply for reentry permit, which is a pre-authorization to be absent from US for a long period of time, up to 2 years, and it can be renewed again for another 2 years. And then, if 1 year and 1 year increments in the future after 2 extensions of 2 years. Very beneficial, helpful to the permanent residence. Okay, does reentry permit need real reason to stay out, or it could be small, like more time to spend with old dad, mom, etc.? Yeah, I've never seen a reentry permit, and we've handled many, ever denied, based on the reasons. The reasons are, I need to wrap things up at my home country, or I need to finish school, I need to finish work, or I have, as you wrote, I have elderly parents that I need to take care of. So reentry permit is very easily approved. It has to be prepared. As I said, there are nuances as to when it's done. Now, if you're planning to travel here, contact us. We will be happy to prepare everything ready for filing. And as soon as you enter the US, we can file it on your behalf. So contact us. You have the contact information there. So we is asking, I have a master calendar hearing in October 2023. However, my mom died in a different country from which I'm claiming asylum. ABS would be buried in August. I want to attend her funeral. I am desperate. I am very, very sorry to hear about that. The immigration court during your removal proceedings cannot give you advance parole to be able to travel abroad. Unfortunately, there is no procedure for that. What you can do, understanding the situation, what you can do is this is probably a very strong reason to expedite your case. You have a master hearing in October. What you can do is, or what your lawyer can do, is file a motion to waive that hearing and to schedule individual hearing together with expedite request. And with all this evidence, you can theoretically be heard within the next 2 weeks. So without a master hearing. So your lawyer would have to file written pleadings, motion to waive the master hearing, motion to set the individual hearing, and expedite request. So there are tools to do that, and I would contact the clerk of the judge, explain the situation, and work and see if there is a gap in the judge's calendar, or if there is a window, some cancellation. Maybe considering the situation, they can do it. Again, I'm very sorry to hear about your mother's passing. Emir is asking, for people entering the US through CBP-1, will the officer ask them why they didn't apply for asylum in countries which they transited on their way to the US? The answer is no, Emir. So that's a very good question. And there is actually news about that transit ban. So I understand, Emir, the reason why you're asking this question. You probably heard of that transit ban, which presumes that the applicant is not eligible for asylum if the applicant traveled through third countries, through other countries, and entered the US and applied for asylum here only. Then the question comes up, why didn't you apply for asylum in the countries through which you traveled? So what Biden administration did, as you all know, with the CBP-1, Biden administration created this process to orderly process all of the immigrants who are coming to the US to apply for asylum. So rather than jumping the fence or crossing the border illegally, or swimming across the river, Rio Grande, they decided that we need to put a stop to it and see who's coming to the US, and also make it safer and easier for those asylum applicants to come into the US and apply for asylum as refugees. So to do that, Biden administration created the CBP-1 process to encourage everybody to apply through CBP-1 process rather than, again, illegally crossing the border. The Biden administration simplified it. They made it as simple as possible. You download the app, register your information, the CBP officer will schedule an interview. Well, I did this. It's not as this quick nowadays. You may have to wait in Mexico for several weeks, and then they schedule an appointment. They ask you very basic questions. They don't even question you about the basis for your asylum, and you're allowed to enter. They schedule a date for your immigration court hearing. You can ask for asylum, and you will be able, you'll be able to tell your case and prove your case there in asylum court, in immigration court. So that's why, they try to encourage the CBP-1. But still, even though with all these simplified explanation, with a simple way, there are individuals still to this day that continue entering the United States by digging tunnels or jumping over the fence or swimming across the river. It's not because they're smart or dumb, it's because they're misinformed or uninformed. And who misinforms them is smugglers. There are groups, there are mafia groups, there are these cartels, there are individuals who make money off of that. So they find those individuals in Mexico, in Latin American countries, or even individuals who are from Europe or from Eastern Europe or Asia and so on, or Africa, and they try to convince them that don't use CBP-1, you will be detained and so on, but we will smuggle you through these ways and you will be able to enter the US without being detained, and then you can apply for asylum affirmatively. This is all BS, excuse my language. That is very dangerous. It's not a good idea. So to make it even more not good idea, the Biden administration came up with a plan that everyone else will have this transit ban automatically applying to them, except the CBP-1 entrants. So the Biden administration passed this final regulation, which says that if you enter the United States illegally, cross the border or so on, or using fake documents, and apply, or just even arrive at the port and request to be admitted without any documentation, which is known as arriving alien, then you will have this transit ban, meaning you will be presumed not eligible for asylum because you could have applied in some other country, except if you enter the United States through CBP-1 process. Now, what happened was this transit ban was criticized by lots of human rights organizations, including ACLU and so on. And there has been a lawsuit filed in the federal court. And the federal judge actually said to the Biden administration, ordered that the Biden administration the president cannot enact such a law on his own that would contradict the asylum laws, that would contradict the laws that are passed by Congress and international laws on the Convention on Status of Refugees, United Nations Convention. So just, I think 2 days ago, the federal judge ordered this to be canceled, this terminated, so the transit ban wouldn't be applying to anyone. Now, at the same time, the same judge, although the judge issued the order, the federal judge also paused his order, so basically put his order on hold because it's going to be appealed by the Biden administration. So the long story short, the transit ban still applies to everyone except those who enter with CBP-1. And they may be doing too much by trying to push everybody to use CBP-1, but I don't blame them, because it's really dumb at this time. It's really stupid to use any other means to enter the United States when you have the CBP-1, it's never been that easy for anyone to enter the United States. And I'm talking about in the last, 70 years. It's never been that easy to enter the United States and apply for asylum as it is now with this CBP-1 process. If you cross the border illegally, if you jump the fence or use smugglers or somebody who's trying to help you cross the border through the desert and so on, it's just you're hurting your case. You will likely be denied, and plus you will likely be prosecuted. I had a client recently who just got released from federal prison, and he was found guilty for crossing the border illegally. That's a federal crime. So anyway, long story short, if you use CBP-1, you are not going to have that transit ban. And if you are coming to the US to apply for asylum, it's just, again, excuse my language, just stupid to do anything else other than use the CBP-1 process. Unless you have a visa, you're coming to the US with a visa, with a dual intent visa, then that might be a better option, and keep your status while your asylum case is pending. All right, a YouTube user says, currently on STEM OPT and been in the US for 4 years. If I go back home for 1 week and come back, can I apply for asylum? Will my current date of entry become last date of arrival for the asylum 1 year rule? Yes, it will technically, but theoretically, you're going back home is going to hurt your case more than returning and applying this 1 year thing is going to help you. So don't go back home if you really have fear of persecution in your home country. And and that will be used against you. Why would you go back home if you're saying that you have a danger there? Why would you go back voluntarily? So don't do it. Now, if you are currently on OPT, as you said, this 1 year rule doesn't apply to you. That's good news. You don't even have to worry about that 1 year. It does apply, but it falls under exception. So whoever you are, YouTube user, consult with a lawyer, okay? Get in touch with me or get in touch with anyone else who's experienced significantly in handling asylum cases. You got wrong information, and I'm glad you asked this, because it seems like you were on the verge of going back home because somebody told you that you have to file your asylum within 1 year, which is true, but it doesn't apply to you because you are in current valid status. So you fall under exception, whether you've been here 4 years or 40 years, it doesn't matter. As long as you maintain your status, you can file asylum anytime before your status expires or within reasonable time. Now that is very catchword. It's vague. So reasonable time can mean many different things, but typically means within about 6 months from the time of expiration of your ending or violation of your status. Now, be also careful with that. If you work without authorization, you're violating your status, and that's going to be held against you in terms of 1 year deadline issue. So if you're on OPT, get in touch with a lawyer, get in touch with me, and I'll be glad to help you to handle your asylum case. And don't worry about the 1 year rule if you maintained your status so far. All right, Amir is asking, will all people entering the US via CBP-1 be paroled to the US, or is there an exception? There are exceptions for national security purposes, or if it's individual who's been sanctioned and so on. But according to statistics, and we had a meeting with my colleagues through American Immigration Lawyers Association, and the statistics show that 98% of individuals get processed without detention. So unless your name matches some known, individual who poses national security risk to the United States, you will not be detained. I'll tell you this way, since the CBP-1 opened recently, we've had numerous clients, consultations, calls, and each time I ask, all of them report none of them have been detained or even close to be detained, and none of them have been asked thoroughly about their case. They've just been asked a couple of questions, biographical information, and processed and let in. Now, that doesn't mean that it's going to happen the same way going forward. And in fact, CBP-1 itself can end any time. As you know, there is a lawsuit pending by the Republican conservative states against Biden administration for utilizing for opening this CBP-1 process. Their claim is that it basically means open borders. Anyone can come in, and nobody knows how dangerous they are because there is not much thorough vetting. Now, the government claims that they're vetting, they're questioning, they're doing thorough examination. But in terms of oral questions, there is no thorough examination. I can tell you that. Is it good or bad? Probably dangerous for the United States. But for individuals who really are deserving asylum and who are refugees who are trying to escape persecution, you want to do it as soon as possible. Now, if you are questioned at the border, you need to be prepared for it because they may. Now, I think they're flooded with the number of individuals coming. That's why they don't even have resources or time. But as you all probably have heard, there is credible fear interview process, which is in the laws, in the books. And they did that in the past. And it's one of the reasons why there have been such huge backlogs, because asylum officers were being sent to the border, or nowadays over the phone or remotely, they would interview those entrants into the US to see even if they have basis to apply for asylum. But nowadays they don't. They automatically process everyone and send their case to immigration courts. And they hired lots of immigration judges to be able to process those cases faster. We sometimes have individuals who enter the US through the border, and we have their individual hearing within 6 months. Within 6 months of their entry into the US, their case is decided. And in most of our cases, not to brag about it, they're all granted asylum. But every case has different facts and circumstances. it doesn't guarantee and warrant the same result. I should make that disclosure anytime I tell you about the case results. Okay, so Abdul is asking, hello, what are some of citizenship interview former asylee? What are some of the citizenship interview former asylee gets? And also how long it takes applicant from New Jersey to get interview? Thank you. So Abdul, I'm glad you asked this question. Seems like you, at one point, you got asylum and now you're applying for citizenship. And that's very, very intricate, delicate process. And citizenship application is where many asylum applicants get in trouble, former asylees. So somebody who got asylum, then they apply for permanent residency, and then down the road, they apply for citizenship. You should know one thing. Anytime you file anything with the US government, whether it's starting from your visa abroad from US consulate when you got your first visa, or if you arrived, you told something at the border, let's say CBP1, you provided the information. All of that adds up into your file. Your citizenship application is the last chance, technically. Now, theoretically, they can denaturalize someone if they catch something, but there is no reason for them to re-review your file down the road unless you do something, there is some criminal case against you, and they're looking into your file. But other than that, there is no reason. So citizenship is technically the last review of your file by the United States government before you are off the hook. Now you got passport, that's it, you're just one of us, right? So at that point, the diligent officer, and most of them are at the USCIS, will open your file going back to the first time you ever filed anything with the US government. And it could be something we filed with the US consulate abroad. And they will compare everything to each other. Your visa, your asylum application, your asylum declaration, your form, your green card application, adjustment of status, and now your citizenship application. And if they find anything that is looking inconsistent or even suspicious, they will grill you on that, and they will take away your green card. They will take away your asylum. And this is real. There are many cases in immigration courts, including some of the clients that now hired me after they got into this trouble by trying to file their own green card or citizenship application, where they are now going through the process of getting their asylum or green card taken away and then being deported because of mismatch of information they provided in those different steps. So be very extremely careful with that. If you're a former asylee and you're filing for citizenship, or not just former asylee. I just recently had a case, recently, meaning several months ago, I closed that case and thankfully we won. I had a case of somebody who applied for a green card based on employment, on the employer sponsoring them. And then many years later, when they applied for citizenship, they provided false, inconsistent information, which the USCIS believed was false. And they placed these people in removal proceedings trying to take away their green cards. After about 10 years of fighting and losing tens of thousands of dollars in this, I was able to win that case and save their permanent residency in the US. But don't fall into that trap. Don't take applying for citizenship lightly for anyone, but especially if you've been a former asylee. So how long it takes for the applicant from New Jersey to get interview, it's just anybody's guess. Typically about all of the citizenship applications that we file, and we file with New Jersey, with all of the states in the United States. It takes typically around 1 year or so. Now, if you have anything that is inconsistent or suspicious, like in your asylum case, you said you were detained in a protest or arrested. Now you're saying you were not. In the citizenship case, you were never arrested or charged. Or if there's anything that is inconsistent or looks suspicious, then it may take considerably longer. The USCIS officer will request your entire asylum file, including the notes of the officer or the hearing information from court, and they will compare everything. So that can delay your process. So I've had asylum applicants who filed for citizenship that that had to wait about 2 years, 3 years for the citizenship to be reviewed and approved or scheduled for interview. Or I had some asylum applicants for which we filed for citizenship that took about 10 months to get their citizenship. So it depends. There is no way to know how long it will take. But the important caveat is that you need to be very attentive and look through all of your previous cases. So for anybody who contacted, anybody who joined us now, thank you very much. This is our weekly live stream where I, U.S. immigration attorney, Ismail Shahtakhtinski, I answer all of the questions from our audience. And you can post your questions in the chat section. I will do my best. We have live sessions, live YouTube sessions and Facebook sessions every Thursday at 12:30 p.m. as the time permits. Sometimes I have hearings during that time, master hearings, individual hearings, although many of them are remote, but I may not be able to do it at 12:30. Sometimes we reschedule it to another time. Next week, it's still going to be 12:30 p.m. So you can join, or you can tell anybody who you know needs or has immigration questions. If you have friends, relatives, acquaintances, colleagues, somebody who needs immigration help, or somebody is asking you immigration questions and they're abroad, but because you're in the US, your relatives may be asking you a bunch of questions, or how can I arrive in the US, what's CBP1, and so on. Send them here, give them the link and say, this immigration attorney provides free answers to the questions of the audience every Thursday at 12:30 p.m. New York, Washington, D.C. time. We are located near Washington, D.C. in Virginia. We're an immigration law firm, and we handle all kinds of immigration cases. You can also contact us for direct one-on-one consultations. We provide consultations online or over the phone. So there is no need to come to our office. You don't have to be in Virginia or in the area at all, or in the United States. You can communicate with me and ask all of your questions directly. Immigration laws are federal laws. So as an immigration lawyer, I'm licensed in Virginia, Maryland, Washington, D.C., and New York, but I can provide immigration law services all over the world in relation to U.S. immigration. So contact us for consultations, and I'll be glad to answer any questions. Now, if you have any questions now, you can post it in the chat section. I will continue answering all of the questions from audience. And finally, again, I would greatly appreciate if you press like. If you like this video, if you don't like these live streams, explain, please post the comments in the comment section or chat section. But if you like it, please show it. I will greatly appreciate that, and sign up to our channel so that you can be notified of our future live streams and video blogs about different immigration procedures and immigration news. Okay, so the next question is from Makoral Omayo. Yes, does your law firm facilitate immigrants get EB-3 jobs with companies recruiting visa sponsorship EB-3 jobs in USA? No, our law firm doesn't, and no law firm doesn't. No law firm, no actually lawful person can facilitate your job for the purposes of EB-3. Anybody who offers you that, they're either crooks, swindlers, or they're lying to you and they're going to take your money. They're doing something illegal. Okay, so it's the first comes job and then immigration EB-3 process. Anything you see online, any websites telling you we will find you an employer and sponsor you for EB-3, they're doing something illegal. That's not allowed. Okay, you can have a recruiting company and you can present your resume. You can find an employer. They can find potential employer who will interview you. And then if they like you, if that employer wants to sponsor you and wait about 2.5 years, they can do so. That's EB-3 means employment-based third category, just for everybody, for anybody who doesn't know. So that employer can sponsor you for your permanent residency. It will take about 2.5 years based on the current processing times and the new system that Department of Labor began recently. So, but nobody can find you an employer. You need to find it, or you can use, as I said, headhunters or any other recruitment companies to find an employer. But those recruitment companies, they don't deal with immigration procedures. So you need to find a job and employer. If you pay someone to find a job who's going to be sponsoring you for that purpose, that's unlawful, that's criminal, and eventually those people will get caught and you will get caught because of that. As I said, I've had many cases. It's real and it happens. It's just those individuals, they don't tell their friends and relatives that I got caught, and that's why you don't hear those. But somebody who gets their permanent residency through EB3, through fake employer, they brag about it. So you hear only the positive news, but not the negative news. So that's why your impression is that, oh, but I have a friend who got a green card through EB3. He paid $10,000, they found him a job, and then he paid another $10,000, they got him a green card. Yes, that friend may have gotten it, but there are many other individuals who got caught. And even that friend may have gotten his green card or her green card, but for the next 5 years after they have the green card, plus some after they file for citizenship. So maybe for next 7 years, they're still eventually going to be more likely than not, they'll be caught. Because this company who does this, they're not just doing it for you, they're doing it for everyone else. That's how these crooks, these illegal criminals, they do these things, is they don't just make money off you and that's it. Now they're happy they got 10,000 from you or whatever you paid them. They do it as a way of living, and eventually they get caught. And Google it, you'll see a lot of these companies, and even unfortunately some immigration lawyers, some of my colleagues in the past who have been caught doing that kind of stuff. So, and they get caught, and every case they touched, every case they had their name in, on every case there was their fingerprints, is going to be pulled up and re-reviewed and reconsidered. So getting your permanent residency green card through this fake process is not advisable. You will more likely than not get caught. It's not that reversed. It's not like you more likely than not you will not get caught, but if you get caught, you'll be like, okay, I'll leave the United States. No, when you get caught, you may be arrested, you may be criminally prosecuted, and you will be deported, and you may never be able to return to the United States. So don't resort to those things. I guess my advice to everyone is don't use those fake companies facilitating job for EB3 purposes. No, you need to find the job. You can use recruitment professional companies that recruit employees to find an employer, and if this employer is willing to sponsor, that employer may have an immigration lawyer they work with, or you can have your own immigration lawyer to work with to handle this employment-based permanent residency. All right. Sendayush is asking, thank you. I have a question. You guys working this Saturday? No, we don't work on Saturday in the United States. Most of the companies don't work on Saturday. Most of the businesses don't work on Saturday, or if they do, but there is other days that they don't work. But our work schedule is 9:30 a.m. for contacting our office, 9:30 a.m. till 5:30 p.m. Well, actually 9 a.m. to 5:30 p.m. Monday to Friday. And this is Eastern Standard Time, Washington, D.C., New York time. So if you contact us, then you can press the link up in this chat section, and you will be routed to our page where you have all of the answers to frequently asked questions about scheduling a consultation. And you can click the link and you will be directed to our calendar, where you can actually book a consultation with me directly in my calendar. You will be able to select the time and date most convenient for you, and you will be able to schedule a consultation directly with me. Okay. If anybody has any other questions, please post it in the chat section. I will answer every question posted as much as I can. Oh, wow, it's already been 1 hour since we started, but I'll still continue. All right, and anyone who joined us, thank you so much for joining. This is our weekly live stream session every week on Thursdays at 12:30 p.m. Time schedule permitting. We do have this live session where I answer questions from all our audience. I would greatly appreciate if you like these live sessions to press like, press thumbs up, whether it's on Facebook or YouTube, wherever you're watching this live stream. And please subscribe to our channel so you can be notified of the important videos uploaded to our channel. All right. So, and please like our page on Facebook, by the way. That also helps a lot. I appreciate it. Anu says that was wonderful. Thanks. Thank you, Anu, for your questions. Omiya is asking, I applied for expedite of my case, but I'm still waiting to hear from them. How long after expediting my case and put on the wait list, how long does it take to be called in? So if you filed your expedite, depends on what your procedure is if it's a with a USCIS, not family reunification, citizenship, or whatever, work permit, and you placed an expedite request over the phone, then you will wait for the email from them. And it typically, as I said, takes about 2 to 3 weeks to get an email saying they can either deny it right away if the basis you provided wasn't sufficient, or most likely they'll just ask for additional documents and proof and confirmation from you, in which case you can provide those via email. Sometimes they ask you to fax that information, but typically email, so you can provide that information and hopefully they'll approve it. Now, once they approve the expedite request, it depends on the specific, location of your case, asylum office, if it's in the asylum office. As I said, some expedite requests get granted, but there is a long line of cases that have been approved for expedited interviews, and there is a backlog of expedited cases now, unfortunately. So there is no way to know. All you can do is write to them. But again, you're still so after expediting my case and put on waitlist. So first, right now you're saying you're still waiting to hear from them. So the first thing for you to do is keep contacting them, or if you have a lawyer, have them contact the USCIS, whatever place your case is in, and keep following up on that expedite request. All right, HSN is asking, do you know how long? Do you know how long does it take to get an appointment from CBP1? So the answer is no. It changes. Some of my clients who we frequently have CBP1 entrants who are contacting us for consultations, or they hire us to handle their case in immigration court, and it varies. So, some of them tell me it took them 2 weeks. Some of them tell me it took them 4 weeks. I just recently heard somebody who's been there for almost 6 weeks now and haven't had the interview. So unfortunately, it's inconsistent. I hear that there are some tricks. You have to re-register and keep refreshing and so on. I don't recommend doing something that is circumventing, but unfortunately, there is no predictability as how long it takes. It used to be consistently about a week or two, but nowadays some individuals report to me that it takes them longer than that. All right, so Melissa is asking, can I withdraw asylum case and resume with F1 after biometrics? Yeah, you can always withdraw your case, asylum case. Now, if you never abandoned your status, if you never violated your F1 status, you can, you can maintain it. You'll basically, you never lost that status, so you can continue studying. But if you abandoned it and now you withdraw your asylum case, it's not that you will be given back your status which you lost. You will not. So you will become, basically, if you withdraw your asylum case, you'll become undocumented, and you may be placed in removal proceedings in immigration court. And withdrawing asylum case is not going to basically erase it from your history. You will still be questioned about, why did you apply for asylum? Was it a frivolous application or not? All right, so I think I missed some of the questions in the beginning. I see that at the very beginning, actually, I don't know, 5:45 a.m., T. Tang asked, hi, sir, how long does it take the final hearing on immigration court? Also has to be the same exact thing that we have to say what we said at asylum offer, I guess, asylum interview. Please let me know. So how long does it take for final hearing? I think you need to listen to the beginning of this video, of this recording, live recording, because that's where I was telling you about the time typically it takes. It can take years, but you can try to expedite it. Does it have to be the same thing we have to say at the asylum office and in your immigration court? No. If you said something wrong at the asylum office, you still have a chance to correct it. Now, if it's completely inconsistent, you want to address it yourself rather than wait for the government or the judge to question you on that inconsistency. But the bottom line is, if your case is in immigration court, you should immediately, and I'm sorry, I got FBI calling me. I need to, it's something to do. I need to pause this. Actually, no, I'll call right back. Sorry, everyone. So, yeah, so no, T, you need to hire an immigration lawyer, talk to immigration lawyer, and let them find what's the inconsistency and what you can do about it. Okay, so Khalid is asking, I get a 3-year student visa and came to the USA if I ask for asylum. As soon as I arrived and my asylum application is not accepted, I will be deported before I have completed my 3-year visa. No, so you're not going to be deported as soon as you are done with, well, okay, my asylum application is not accepted. What do you mean it's not accepted? If I ask for asylum and my asylum application is not accepted, will I? Now, if your asylum application is not accepted, you will just be denied asylum. And then once you're done, you complete your student visa is not 3 years. So the visa is for entering the United States, but then you have a status here. Your status continues until until you're done studying and you're done with OPT and so on. And if you lose your status eventually and your asylum case is denied previously, then you can refile it and your case will be sent to immigration court, where you will have a chance, the second chance, through immigration court to prove your case to the immigration judge. All right, so let me see if I have any further questions. I do have 3 more questions for anyone who joined us recently. Thank you so much. I'm about to wrap up this live session where I answer all of the questions from my audience, and I tell and I describe one of the immigration procedures or share immigration news. Please press like, please subscribe to our channel, and let me answer these 3 more questions and I will wrap this up. And you're welcome to join us again next Thursday at 12:30 p.m. Washington, D.C. time. Okay, so next question is, Imam, after expediting my case and put on waiting list, how long will it take before they call me to the interview? I already answered that question, I believe. I'm just rereading this asylum application. So after expediting the case, again, there is no way to know. It may take some time. Typically, it takes anywhere between several weeks to several months. We have a case which has been expedited about 8 months ago and it's still pending. And when we write to the asylum office, they tell us that they have too many cases that have been approved for expedited interviews. So nobody knows. And the next question I have is, can a green card holder file for asylum? Yes, green card holder can file for asylum. Thank you for the question. Not everybody knows. And some may say, if I'm a green card holder, why do I need asylum? Well, because green card doesn't provide you the same protections that asylum does. So asylum gives you status of refugee. You can be protected in the United States. You will be protected outside of the United States by the United States, because now you're the subject. You're a refugee in the United States. You will get a travel authorization, which is a travel document, which is a refugee travel document, which will substitute your passport. So it's similar, not exactly, but it's similar to having a U.S. passport. The green card doesn't give you that. Green card is just a permission to stay and work in the United States. You're not protected by the United States. But as a refugee, you are. And plus, as a refugee, you will be eligible for some benefits, some things that permanent residents are not eligible for. So green card holders can apply for refugee status, for asylum, and get asylum status. Does it make sense considering the length of time you'll have to wait for asylum, by which time you can probably become a U.S. citizen? So those are the factors that you should consider. I had a client who became a U.S. citizen while waiting for asylum interview. So eventually we sent him a copy of his U.S. passport to asylum office saying, please, his closest case, he's now U.S. citizen. All right, so I'm done with questions. I see one more question from Emir, and I will answer that. Can I do adjustment of status through marriage without having a lawful presence if came through the border? Depends. If you entered as arriving alien, so if you came through the border and you have a notice to appear in immigration court, on the top it will have a check mark. You're an arriving alien. If you're arriving alien, you can do adjustment of status based on marriage. If not, then you may have to leave the U.S., go through U.S. consulate, but then you may have to file for waivers, which can be problematic. So consult with an immigration lawyer if you entered the United States without a visa and you are marrying. Even if you did with visa, still consult with an immigration lawyer and see what we can help you with. it's worth it. It's a good idea to use an immigration lawyer for this purposes. So thank you very much, everyone, for your questions. I have to go, but please join us next Thursday and on 12:30 at Washington, D.C. time. And the next week's topic, I want to share that with you, is going to be on, and I'm sorry, how, the traps, how to avoid traps for asylum applicants, do's and don'ts for asylum applicants. So I will tell you about frequent traps that people fall into when they apply for asylum, things that they get caught off guard with, and what to do to make sure that you don't have any inconsistency or any mistakes which can cause your asylum being denied for one or another reason, whether it's an asylum office or immigration court. So thank you, everybody, for joining us. Again, if you liked this video, please press like. Please like us on Facebook, like us on YouTube, and subscribe to our channel. And thank you so much, and have a nice rest of the week. Bye-bye.